Hi there, I hope you're doing great. So, we meet once again, and today we are going to be looking at a very vital topic known as execution, and we'll be looking at a number of elements. But please, before we start, do not forget to subscribe to my channel so that you're able to always get notifications, and also do not forget to click on the notification bar down so that you're able to always get alerts whenever new videos are released. So we are going to proceed and look at a very interesting topic known as execution. So in today's video, we are going to look at the definition of execution, what exactly amounts to execution. Then we will also look at the modes or the various modes of execution. Then we'll also proceed to look at who chooses the mode of execution. Okay, is it court? Is it the plaintiff or the judgment creditor or judgment debtor? So we will look at who chooses the mode of execution. Then we'll also look at the timelines within which to execute. Okay, how much time do you have to ensure that execution is carried out? Also in this video, we will also be looking at what can and cannot be executed against. We will also look at the steps of execution or the procedure of execution. In this video, we'll also look at the procedure of preparing a bill of costs, and then finally, we'll look at what documents are needed for execution. So we are going to start right away, but before we go into the gist of our discussion, it's important to always note, every time you're faced with a question on execution, you should always be able to identify the following. One, is this execution on a private person or company? Is it execution of immovable or movable property? Or is it execution against the central government or against the local government or against an organ of the central government? These distinctions are always important to make from the onset because it helps you determine how you will proceed and the various laws and regulations that apply there under. But for purposes of this discussion, we're going to be looking at specifically execution against private persons or entities. So let's proceed right away to look at the definition of execution. So execution, basically, this is where the plaintiff or the judgment creditor emanates on a journey to realize the fruits of the judgment. So this is where you're trying to get back the losses or maybe to get back the benefits of the judgment. Authority, look at the case of Unique Holdings Limited versus Business Skills Trust Limited. This is High Court Civil Suit number 402 of 2012. And in that case, execution was defined to mean the process of enforcing or giving effect to the judgment of court. And it is completed when the judgment creditor gets the money or thing awarded to him by judgment. Okay, so basically that is execution. Okay, let's now proceed. After looking at the definition, let's now proceed to look at the various, let's look at the timelines. Okay, within what time must the judgment creditor? Now, when we talk of a judgment creditor, here we mean the party who has got the case, the judgment in their favor. That's a judgment creditor. Then the judgment debtor is the party against whom a judgment has been entered, the person who has lost the case. So basically, the timelines are as follows. You have to carry out execution within 12 years. This is very, very important. So the limitation is 12 years. After 12 years, you are stopped from carrying out execution, of course, with some exceptions, as we will see under Section 35, subsection 2 of the Civil Procedure Act. But please note, the general rule is that 12 years is the time within which an execution must be carried out. Authority, look at Section 35, subsection 1A of the Civil Procedure Act. The exception is under Section 35, subsection 2 of the Civil Procedure Act. This is where, on application to court may grant you an extension of time after the expiration of 12 years within which you can make an execution. Having looked at the definition, having looked at the timelines, let's now proceed to look at the various modes within which an execution can be carried out. So the modes are basically provided for under the law. I invite you to look at Section 38 of the Civil Procedure Act. It provides for the various modes, and those modes include: one, delivery of any property specifically decreed. So the first mode within which an execution can be carried out is for you to deliver the property. Secondly, attachment and sale. You can also execute by attaching property and proceeding to sell it so that you can retain the money, so that you can get back the money to satisfy the judgment. Next, attachment and sale. You can also execute, we have talked about attachment and sale. Now, it is attachment and sale or sale without attachment of any property. So you can attach the property and sell it, or you can actually sell the property even without attaching it. That is the second mode of execution. The third mode is attachment of dates. Attachment of dates, you can proceed to attach a date, the so-called garnishi. Okay, the judgment data has certain money on an account or somewhere, or maybe it is in possession of a third party, let's say bank. You proceed to attach that money, okay, the so-called garnishi. The other mode is arrest and detention in prison. Okay, you can decide to arrest the judgment data and then you imprison them. It is also a mode of execution. Then lastly, appointing a receiver, the so-called appointment of a receiver. Now, the judgment data may have a business or an entity which is making a profit. So you can proceed to appoint a receiver who receives money from that entity, and then the money is passed on to the judgment creditor. Authority, where are those modes provided for? Please look at Section 38 of the Civil Procedure Act. It provides for those various modes. Let's now proceed to look at who chooses the mode of execution. Who chooses how to execute? Is it the judge? Is it the judgment creditor? Is it the judgment debtor? Who chooses the mode of execution? So, ladies and gentlemen, the principle is a judgment creditor will choose their own mode on how they will execute. So it is the judgment creditor or the plaintiff who chooses their own mode. Authority for that position, look at the case of Mandaria versus Ratam Singh, a case of 1968, East Africa, page 141. So in this case, court held that it is the decree holder to settle or to select the appropriate means within which to execute his or her decree subject to their own discretion. So the judgment creditor will choose how to carry out the execution. Having looked at the definition, the modes of execution, having looked at who chooses how to execute, and also having looked at the timelines, let's then proceed to look at what can and cannot be executed against, the so-called scope of execution. So the scope of execution is under the law. When you look under the Civil Procedure Act, it provides for what can be executed against and what cannot. For example, when you look under Section 44 of the Civil Procedure Act, there are certain things within which you can execute on, and those are under Section 44, subsection 1. Some of those things include land, houses, buildings, goods, money, banknotes, checks, bills of exchange, promissory notes, government security bonds, shares in a corporation, among others. So those you can execute against. But the law also provides for certain aspects of which you cannot execute. And those aspects are under Section 44 still, especially from Section 44A up to J. And just in summary, some of the things you cannot execute against, these include wearing apparel, such as clothes. These ones you cannot execute against. Cooking vessels, beds, and beddings. You cannot execute a mattress, things like bed sheets, a bed cover, things like saucepans. You also cannot execute working tools of someone. For example, if someone is a farmer, you cannot execute their hoe. You cannot execute against their machinery. That is very, very important to note. You also cannot execute bank books of accounts. You cannot, the law does not allow you. You cannot execute against a mere right to sue for damages. If someone has a right to sue for damages, you cannot execute against it. You cannot also execute against the right of personal service. You also are prohibited from executing against stipends and gratuities allowed to pensioners or money of pensioners that is prohibited under the law. Okay, the salary. Okay, you cannot execute against someone's salary, but please, you have to ensure you have to be careful on the aspect of salary because it has certain limitations within it. Also, a right to future maintenance, you cannot execute against that. Also, you cannot execute against certain funds, okay, that are prohibited by law. So basically, for purposes of what you can and cannot execute on, that is governed by Section 44 of the Civil Procedure Act. So let's proceed to look at steps of execution or the procedure for execution. So, assuming you have got judgment in your favor, you're a judgment creditor, what steps will you take to ensure that an execution is conducted successfully? I need you to buckle up because the process and the steps are a bit long, and within those steps we will also be looking at the procedure for preparing a bill of costs. So I'm going to give you the steps or the procedure of execution, and within that procedure I will also briefly take you through the steps or the procedure for preparing a bill of costs. Very important. So the procedure for execution is as follows. The first step is you peruse the judgment and understand the orders that have been made by court. So first peruse the judgment, understand the orders. Okay. Authority, look at Order 21, Rule 3 of the Civil Procedure Rules, which provides that the judgment should be typed and signed. So the judgment must be typed and signed. Go through it and understand it well. The second step to note is extract a decree from the judgment. So after judgment has been made, please note that there is a difference between a judgment and a decree. Although they are related, but they are different. So the second step is you proceed to extract a decree from the judgment. Authority, look at Order 21, Rule 6, Sub-Rule 1 of the Civil Procedure Rules, and then also look at Order 21, Rule 7, Sub-Rule 1 of the same rules, and also you look at Section 25 of the Civil Procedure Act. All these are authoritative. And also of interest, you can look at Order 21, Rule 7, Sub-Rule 3, okay, which provides that in the magistrate's court, the decree is drawn up and signed by the magistrate who pronounced the judgment. Okay, very important to note at that stage. Let's proceed, and also before we proceed on the third step, I interest you to look at the case of Assad versus Livingstone or Waller. It's a case of 1985, High Court Bullet, page 50. Court found in that case that the general duty of extracting a decree is imposed on the successful party. So it's the judgment creditor who has the duty to extract a decree because it is presumed that he will be anxious to realize the fruits of his or her judgment. Let's proceed to look at the third step. The third step is preparation of the bill of costs, and you cause it to be taxed. So you prepare a bill of costs, and then you have to ensure that it is taxed. Authority, look at Section 95 of the Civil Procedure Act, Cap 71. The general rule is that costs shall follow the event. Costs must follow the event. Also to note is that the bill of costs must be prepared in accordance with Regulation 47 of the Advocates Remuneration and Taxation of Costs Regulation, SI 267 to 4. So you have to ensure that that is done within the regulations. Okay, that is the preparation of the bill of costs. Let's now look at the procedure of preparation of a bill of costs. Okay, let's look at the procedure of preparation of bill of costs. Now, when you're looking at the procedure of execution, do not include the procedure of preparation of bill of costs. But however, next time you could be tasked, okay, to state or to lay down the procedure of taxation of the bill of costs. So you should be in the know, and that is why I'm going to bring it to your attention. So the procedure is as follows. 1, list down all the expenses on the case. 2, you date the bill and you sign it. You date the bill of costs and then you ensure it is signed. Thirdly, you file it for taxation with the registrar. Then you proceed to pay the requisite fees. Then you proceed to extract hearing notices and file them together with a bill of costs in the court registry. This is very important. Next step is you serve a copy on the opposite party, and then you proceed for a hearing. After that, the taxation master will issue a certificate of taxation. Authority, look at the case of Behanj Jennifer versus School Outfitters Limited. It's a case of 2001 UCCR. That case provides for the procedure of taxation of a bill of costs, as I have briefly discussed for you. So, having looked at that procedure, let's now proceed to look at the fourth step, okay, of the procedure of execution. The fourth step is issuance of a demand of payment from a judgment creditor. So you have to go on and issue a demand, okay, to the judgment debtor to ensure that they pay. Okay, you demand them because they already know that they are the judgment debtors. So you issue that. Now, serve the decree and the certificate of taxation on the judgment debtor with a formal demand letter. So you serve them together on the judgment debtor. The formal demand letter together with the certificate of taxation are served on him, requesting him to make payment of the money. Identify what is to be attached and investigate the owner of the various properties of the judgment debtor. That is also very important. It's under the fourth step. The fifth step is if no compliance is made, assuming you serve them a notice to pay, but they don't comply, okay, execution proceedings can be commenced. You then now commence execution proceedings. Identify the mode of execution. So you, the judgment creditor, you choose your own mode of execution. Authority, we already talked of it. Look at section 38 of the Civil Procedure Act. Also look at the case of Mandiria versus Ratan Singh, the case that I already gave you. It is the decree holder where court stated that it's the decree holder that chooses their mode of execution. The fifth step of execution is to prepare and file the application for execution. Okay. Authority, look at Order 22 Rule 7 of the Civil Procedure Rules. Also look at Order 22 Rule 8 Sub Rule 1 of the same rules. Also look at Order 22 Rule 8 Sub Rule 2 of the same rules. And also look at Order 22 Rule 10 of the Civil Procedure Act. It is very authoritative. Also important to note at this stage is that the application ought to be filed together with the filing fees. So they have to be filed together. And then also the application for execution of a decree may be made orally or in writing. So you can make this application either orally or in writing. It is all okay. Having looked at that, we are still on we are still on the sixth step. Okay. Also on the sixth step, I interest you to look at Order 22 Rule 11. Okay. And also the case of Mwamba Kahire and another versus Abudi and Sons, a case of 1986, Kampala Law Reports, page 144. In this case, court held that property, which is the subject of attachment in a warrant, must be reasonably and accurately described. Otherwise, the attachment is inoperative. Important to note. The seventh stage or the seventh step to follow is a notice to show cause. So you have to issue out a notice to show cause. Authority, look at Order 22 Rule 19. Okay, a notice to show cause is simply a document showing for the judgment debtor to show cause, to give reason why execution should not proceed. Okay. Also, the other authority to look at on a notice to show cause, look at the case of Peter Gukina versus Paul Karwanga. It's a case of 1991, High Court Bullet, page 72. In that case, it was held that a notice to show cause is mandatory where an application for execution is made 12 years. Okay? When an application for execution is made after the expiration of 1 year. So the moment you're putting in an application for execution after 1 year has passed from the time court gave judgment, then it is mandatory for you to attach a notice to show cause why execution should not issue. Now, if the application is admitted, the court may then order execution under Order 22 Rule 14 of the Civil Procedure Rules by issuing a warrant bearing a court seal. So the warrant must bear a court seal. Then the seventh step is process for execution stroke warrant. Authority, look at Order 22 Rule 21 Sub Rule 1 of the Civil Procedure Rules. And this one provides that where the preliminary measures have been taken, court shall, unless it sees cause to the contrary, issue its process for execution of the decree. Also, I invite you to interest yourself in Order 22, Rule 21, Sub Rule 2 of the Civil Procedure Rules. It is also very authoritative on the same. The ninth step is appointment of a bailiff. So you then proceed to ensure that an appointment of the bailiff is done. Now, the registrar here issues a warrant of attachment to the bailiff, directing him to sell property therein stated. So the registrar will instruct the bailiff to sell the property that is stated under documentation. Authority, please look at Rule 4 and 5 of the Judicature Court Bailiffs Rules, SI 13 to 6. The bailiff and those rules, those two rules 4 and 5, provide that the bailiff must carry out the directions of the warranty and failure of which he may be personally sued. It's also important to note that where a bailiff goes on to make wrongful execution, the bailiff can be personally held liable for his own actions, especially when they involve themselves in fraudulent activities, okay, misrepresentation, conniving, among others. These bailiffs can be held personally liable for their actions. So, ladies and gentlemen, having looked at the procedure, and that is the procedure in detail, let's now proceed to finally look at the documents, okay? What documents are needed for execution? If you're going to proceed with execution, what documents? You may be asked to draft these documents, okay? So you should be in the know. If you cannot draft them, at least know them offhand, but please, I encourage you to ensure that you immediately, before close of today, you go and practice and ensure that you can draft these documents. So what documents are necessary? One is a decree. That's document number 1. Then document number 2 is a notice to show cause. That one is also paramount. Then document number 3 is an application for execution. You need to put in an application to court to allow you to execute. And then lastly is a letter of demand for payment. Remember, we talked about the letter for demand, where you have to first demand the other party to make payment. So those are the 4 documents that you need for execution. So, ladies and gentlemen, that was all on execution. I will release another video where I will look at execution against government or government organs and local governments. Thank you very much for listening in. Please do not forget to subscribe. Ensure that you click down and subscribe to my channel. Also, do not forget to turn on your notification bar so that you're able to always receive notifications on my channel. Thank you very much. Bye-bye.